Welcome, everyone.
Top of the morning. Yeah, we got our leprechauns here for good luck.
I am so excited on this topic, funding. Funding, kind of a misconception, funding the trust, transferring assets to the trust so that the trust can do its job to avoid probate. But this is such an exciting topic for me, and I love inbound calls, always calls, so I love the inbound calls asking about funding because it means we're going to the next level. You have your estate plan with us, and now you're maintaining that estate plan and you're funding your trust, and you're really getting your head around what this trust is accomplishing and how it accomplishes it in the future. So here we go, funding.
Oh, we're supposed to introduce ourselves, sorry.
Carolyn does a great job of introducing us.
Carolyn,
Rich Brown, AmeriEstate Legal Plan Client Services, and Michelle
Reese Johnson, VP Sales and Marketing, and I take out the trash too. No, just kidding.
Okay, on to funding. Exciting topic. We thought we'd start with the most important asset to avoid probate, the real estate. And that's the key one. And that's the one around here that AmeriEstate doesn't rest until we're very, very comfortable that your real estate is properly funded in your trust. So Michelle, talk to us about funding real estate.
Great. Well, we're going to talk about the most common assets that people have at the top, because it's top of the morning, right? The number one asset, the number one reason for assets that people get a trust is their primary residence. That's what we usually buy first, is a house. So when you buy a house, you need to put it in your book. How do you put a house in this binder? How do you do that? Well, it's called packing. It's like, this is your suitcase, you want to pack it. How do you pack it? It's called funding. How do you fund? Well, you do a deed from you as a husband and wife as community property and joint tenancy, which is probably how you have it titled before you come to AmeriEstate. And we do a quick claim deed or sometimes a grant deed. We take it from you as John and Janet Jackson, husband and wife as joint tenant or community property. Quick claims to John and Janet Jackson, trustees of the Jackson Family Trust, dated July 12th, 2014. That deed is prepared. We have all the proper forms that go to the county recorder's office. The notary brings that out to you with your trust to get the whole book signed, and you sign your name, transferring that, quick claiming that, or funding that, all the same thing, from you as husband and wife to you as trustees of your trust. We then send that off to the recorder's office and you're done. You are funded, your house is protected, there's no probate if anything should happen to you, period. Done. The second most important asset that people have is oftentimes maybe a rental. So a rental is the same thing, it's real estate. Land is also real estate. It has a deed.
Might throw manufactured homes in that category.
Yeah, could be. You could have a manufactured home that you own the land on. You also might have a deed of trust that you have taken a note back. Let's say you sold your house. We don't see this as much right now because the rates have been so low, but they're climbing a little bit, right? But back in the day when I was selling real estate, a lot of people took back a note when they sold their house. Guess what? That note is maybe $200,000, $300,000, $400,000. And that note needs to also be transferred into your trust. So it's called an assignment of, what's it called?
Assignment of deed of trust.
Assignment of deed of trust. So if you decided maybe you're going to, you like the fact that you want to actually have a note on a property because you're getting great interest rate rather than with 0% at the bank, right? Or 2% now, you can have a note. You need to pay attention to that because that note will go to probate because it's attached to real estate. So make sure that you, think back if you have any notes, those need to also be done. we also want to talk about,
When we talk
Time
about
shares.
funding, Karen made a good point. When we talk about funding, it's not like you're transferring money. You're retitling assets to the trust. The trust is
Right.
funded. The trust is the title of the asset is transferred to the trust. I mean, that's our expression for funding.
Yeah.
It's not a money move or anything. It's a retitling. Effort.
retitling. And another thing a lot of people have are timeshares. So we invite you to call us. It just depends on what type of title you have on that timeshare. You could own a deed. A lot of people own deeds. Some people just have points or they have a certificate. It's different depending on the timeshare you have. Hawaii is kind of a lot of the timeshares there are very expensive. And those normally should be titled into a trust. We have an attorney we can refer you to there because we don't touch Hawaii. It's crazy over there. Everything's expensive and they have 2 different recording systems and it's crazy. So we have a great resource for you if you want to retitle one of those crazy Maui timeshares you have that's worth $50,000 or more, because these things are pricey. Well, there's timeshares in Newport that are also pricey. So you want to make sure those expensive timeshares probably get retitled into the trust through a deed transfer. We can help you with that. Or if you have a point or a certificate, go to your timeshare company, bring the abstract of trust or your trust certification, which in our book is section 4, and call them up and say, I would like to transfer title of my timeshare from my wife and I as owners to my wife and I as trustees of our trust. Simple as that. It's just paper pushing, recording, signing, notary, and you're done.
Good thing to keep in mind. There's reasons for the property to be titled out of the trust, refinance purposes. If that happens, I'd say check your tax bill every year. There should be some abbreviated reference to the trust. And sometimes I get that call, hey, my folks' property is out of this trust. What's going on? Well, a refi took it out and we need to put it back in. So, make sure your property remains titled in the trust. If it ever needs to come out, it needs to get back in.
Right.
Very, very important.
It's okay if it comes out. We would prefer that lenders don't make you take it out of your trust to refi it because they don't pay attention to putting it back in. You have to be proactive and your own advocate when it comes to all your real estate. And we've seen a lot of refining going on in the last years, right? So check those property tax bills. Make sure that house is titled into the trust, and it'll say maybe the family TR for trust, or Joe and Kathy TTEE trust.
Exactly.
You know it's in the trust by that property tax bill. Okay, so check out your tax bills if you're refied, and if you need to put that back in the trust, we can help you with that. So give us a call.
And often overlooked, banks are very accommodating for the refi purpose to pull it out of the trust for you. But then you say, well, I need to get it back in. And they say, we don't do that.
Yeah, they won't do it. They won't do it. So they say it's too much liability or something, but you just need to get that titled into your trust. So that's great. So we've got homes, investments, lands, deeds of trust, timeshares, manufactured homes, and the land that sits on that manufactured home. Let's talk about the next most popular or common asset that people have.
Very quickly, Michelle, I think we wanted to say, what if you're on title with another person, joint tenants with another person, tenants in common with another person? There's a decision to be made.
Right. There's a lot of people come to us where they've bought a piece of property with maybe their brother or a friend, or all of a sudden we see a deed with a son on title. And the first question we want to know is, why did you put that person on title with you if it's a child? And number 2 is, but the most important thing is, what do you, as the real owner of that property or your share, what do you want to happen to your portion of that share?
That's
should you
the key
pass
question.
away?
What do you want to happen to your piece
Right.
of that?
So
If you're in joint tenancy and flow to the other joint tenant, perfectly logical, acceptable, the trust stays out of the equation. If you want your 50% to flow a different direction, you might retitle your 50% into your trust, and then whoever inherits it from your trust owns it with that other person. But that's a discussion we'll have with you, and we'll set it up just exactly how you want it when you pass away and where you want that property to go.
right, exactly. So it just basically comes down to, if I pass away, where do I want my share of that property to go? We do see a lot of clients coming to us who are looking to set their trust up, and we see a daughter or a son on title. And most of the reason is people didn't know what to do, and they just throw their kid on title because they think, oh my gosh, what if something happens to me? I want to make sure that property doesn't go to probate. Well, you might have seen this in a previous webinar, but mom really wants that property to go to all 5 kids, not just Junior, but Junior's on title with mom. If mom passes, Junior gets the house. The other kids don't get it. If Junior chooses to share the house with the siblings, okay, but it's not the best way to go to throw a kid on title with you. Let's take him off and put that into your trust. And then you can share it with all the kids, and it's a better situation because there's no capital gains and all that kind of stuff going on. There's more to the story, but
We've received that call that, hey, I just chose to put my kid on title. He's going to get that property anyway. I chose to put him on title today and bypass the trust. Lots of consequences. We would love to have that call prior to that maneuver. Potential gift tax in play, potential capital gains problem in play, lots of consequences. The other thing, when you put your kid on title, you just expose that property to that kid's litigation. What if he gets in that car wreck, but the trust the trust will distribute the property, and there's no reason to add people on title. Let the trust do its job.
Hopefully everybody can hear us. I did get an email, a text from somebody saying they're having audio problems. So hopefully, others are not having that same situation, but yes, this video will be recorded and we will email it to you all. And we usually do that within 5 days after this, so don't worry. A couple questions. I'm going to pop into some questions since we're on these subjects, and then we're going to go to the next subject. One is, if you pay up your rental property, do you need to do anything? No. Your property is paid off as long as that you have 2 deeds. When you buy a house, you have a grant deed where somebody's actually signed over their property to you. And then if you're going to get a loan, you have a trust deed or a deed of trust. I forget, what the name. Anyways, you have the note from the lender and you have the ownership of the house. So your note from the lender is oftentimes just in your name, sometimes in your trust. And as long as your house is in your trust on the actual grant deed, once you pay off that note, as long as this part is in the trust, you're good. You don't need to do anything. It's just paid off. Congratulations, you paid off your house. Another one is, I created my trust in 2013 and bought my home in 2020. The deed is in the name of my trust. I put a copy of the deed in my trust book. Do I need to have my book notarized again? No. Just put a copy of that signed notarized deed in your trust flat book. You're good. Perfect. All right. Let's see, if you have an investment asset and there is a pay on death on the account, should you be concerned with probate? We're going to get into that. This is our next step. It's a
Good segue question.
Yeah.
The next set of assets we think are the most important to consider for the trust: checking, savings, stocks and bonds, CDs, brokerage. Okay, several options. We could say on its face, create trust assets. Very logical, very straightforward. Now all those assets are going to avoid probate. But I get a call out, hey, Rich, I went to change my checking account to my trust, and the bank said, no, you got to close that one and open up a new trust account. But Rich, I have my online banking, my Social Security checks deposited there. Okay, option 2, you could name a direct beneficiary. Banks often use the expression payable on death. You can name a direct payable on death. And you can name the trust as the payable on death. Then upon evidence of your passing, it's released to the trust. The trustee has access, can administer it through the trust, no probate. You also have the option to name the kids directly on the instrument. Jimmy and Bobby, 50-50 beneficiaries, payable on death on that checking. It will bypass the trust. It will still avoid probate. But keep in mind, what if the meteor takes out the family picnic? Then that asset hits a brick wall. Why don't you name your trust as the ultimate contingent beneficiary? Always there as a safety net to gather up that asset. That concept works with checking, savings, brokerage accounts, CDs, non-qualified accounts. accounts that are after tax. We're going to talk about qualified accounts in a minute, a little special consideration, but all after tax accounts, checking, savings, CDs, it works for stocks and bonds too. Are they sitting in a brokerage account that you could convert to the trust? Name a direct beneficiary, name the trust as the beneficiary. Several options, all accomplish the probate avoidance that we're seeking.
There are several ways to do this thing.
And so, should we migrate to the qualified accounts? I think that was what we're going to talk about next. Well, qualified accounts, pre-tax instruments, they qualify for a delay in taxes. So that's going to have a tax consequence in the future. We used to have you send it right through the trust. And I say through the trust, that's what happens. It flows through the trust, goes to the beneficiaries, and they have options on the way they can take that instrument. One might say, hey, take your taxes, take your penalties, just give me my big check. Another might say, no, roll mine into my own retirement instrument, and I'll pay those taxes as I withdraw that in the future. Well, they changed some laws in 2020, and the trust restricts the options available to a beneficiary with respect to the distribution. So we're recommending on qualified or pre-tax instruments that you name direct beneficiaries on those instruments. That will give those beneficiaries the most options available for the future distribution of that asset to them. But
it's called the Secure Act of 2020.
Secure Act 2020, Google it if you want.
Talk to your financial advisor.
Yes. But the kicker is if those kids are minors, there's so much, or special needs. There's very complex rules when a minor gets entitled to an instrument like that. So we would probably recommend that you steer it to the trust until they become an age of outright distribution, because with the trust, the trustee can come manage that for the minor without any fanfare. It won't be complex. But if an instrument's direct beneficiary to a minor, you got to get a custodian, go through a judge. So if they're minors, even if they're qualified or pre-tax instruments, steer it through the trust. But beyond that, name direct beneficiaries for the most flexibility to that beneficiary.
So let me kind of be a little clearer for you. Qualified accounts are things like 401ks, IRAs, most annuities. Anything else? Oh, just any kind of retirement fund that you have. It could be from your teacher, whatever they have, whatever they call it when you're a teacher. It's just, that's what a qualified account is. And most of the time, if you're married, you have your spouse as the primary beneficiary, right? You want to put either your trust as the contingent. If you have minor children, special needs children, you want to make sure that the help money is managed for your kids until they're a specific age, so they just don't get access to it and they could just blow it. But if your kids are adults and have their own, are really good and there's no issue, go ahead and just put your direct children, if that's who you want your contingent fund to be, if your spouse dies, put their names on as long as they're at least 18, you feel like they're responsible and they're not going to blow it and they can manage their own money. That's the best recommendation. But if you don't have children, you could put the trust as a beneficiary or just maybe a nephew or whoever you wanted to get it, as long as all those, they're not special needs, they're not minors, they're responsible, you can go ahead and do that too. Okay.
Do you want to migrate to businesses?
Yeah, let's do it.
Okay. Corporations, LLCs, partnerships. Okay. If you have your trust and you're creating the entity, you could make the member or the stockholder of the entity, the LLC, the corporation, the living trust as the original owner. Most of the time, we have people that come to us for the trust creation originally, but they already have this corporation or this LLC. We will do an assignment. We will assign all your interests to the trust through a notarized document that you retain with your trust in the assignment section. So you want to make sure each of those business entities has a direct avenue of distribution. by virtue of the original owner being the trust, or stockholder, or member in an LLC environment. It's called membership interest, or your partnership. Or we assign it. We have assignments for partnerships. We have assignments for LLCs, corporations. So you want to make sure that it's very definitively pointed to the trust in some fashion in order to avoid probate. And that's, again, our ultimate desire. So that's business entity.
Somebody wants us to talk about life insurance. Life insurance, I consider it a qualified account, but it's not qualified. It's just life insurance. So with life insurance, you are the primary insured, right? There's insured and owner and all that. You want to just make sure that you have beneficiaries listed on that. If you're married, you probably are going to have your wife. And then you just go and put your kids, or you could put the trust as a contingent beneficiary.
Or the primary, right, Michelle?
Or you could put the trust as a primary on life insurance, because life insurance is not a qualified account. It's just here's your money. There's no tax issues and all that. So check your beneficiary designations. This is a great time to do it. Tax season is here. Go in and make sure that you have all your beneficiaries set up correctly on your qualified accounts, IRAs. Look at your annuities and check your life insurance. Make sure that you have updates there, because maybe you've lost a spouse and you haven't updated it. Super important, because guess what? That will go to probate if all you had was your wife and then you pass away. Your kids might have to go through probate on $1 million life insurance policy. So beneficiaries are super duper important to maintain.
I like to inject about now, Michelle, my overall concept again. We talk about funding or transferring title to the trust. Well, that's one element. You just want to make sure that each and every one of your assets has a direct avenue of distribution. As a trust asset, it does. The trust has the beneficiary structure. As a non-trust asset, you want to name beneficiaries, individuals, spouse first, kids second. Trust is the ultimate contingent, or conceivably trust as the primary beneficiary. But you want to make sure that each and every asset has a very distinct avenue of distribution. That's the overall concept here. I know we talk about funding and transferring title to the trust, but you see we're migrating into non-trust assets and other options that can bypass the trust.
Yeah, there's
obviously
different ways to do it, guys. So because even if you have a living trust, some people just don't want to hassle retitling that bank account, it's fund money into their trust. Maybe they're married and they have a side account with just their name on it. This is I just like to play in the stock market. I open it up by myself. My wife has nothing to do with it. It's just in my name. Okay. If you want to just leave it in your name, put your wife on as a beneficiary and make a backup plan on that. You're fine. Don't worry about it. Okay. So just know that. One more thing I want to discuss is, if you have like a business and you have an account in the name of your LLC or corporation at the bank, you leave that account in that name, period. You don't transfer that to the trust. What we do for you is we do an assignment of that business to the trust. You can call us, we'll prepare that for you. And then what you need to do once you sign that business and notarize it, you want to go back into your corporation and reissue your stocks, or your member interest will help you reissue it. So your member interest won't be in your name anymore. It'll be in the name of your trust. So you leave your business accounts exactly the way they are at the bank.
Michelle, are you saying that if I assign my corporation or my LLC to the trust, everything that entity owns comes with it and I don't have to monkey with it any further?
Correct.
Excellent.
And it'll avoid probate. So don't forget about your corporations, LLCs, and partnerships. And your partnership interests, a lot of times, like maybe you have an REIT, real estate investment trust, where you've invested. When you invest in these things, invest in use the name of your trust. You and your wife as trustees of your trust. Keep your ownership with those entities in the name of your trust. You're good. Okay.
If you acquire new assets tomorrow, next week, next year. Close those assets in the name of the trust, right out of the chute. We get this call all the time, Rich, bought a piece of real estate last week, need to get it in my trust. Gee, I wish you would have called us. We would have had you have escrow title it in the closing, right in the name of the trust, and avoided that extra step with us. So when you acquire assets in the future, and makes me think, we suggest you review this, once a year? Funding once a year. Check all your assets, make sure, have you acquired new assets? Have you lost assets? Make sure that all those assets are appropriately directed to a probate-free environment with a direct beneficiary or the trust, obviously.
And call us if you have questions, but you don't need to call AmeriEstate every time you buy and sell something. If you're a client, if you buy a house, you don't have to call and let us know. Just remember the rule. What's the rule? That house should be titled into your trust. Just do that. List it in section 6 of your book. If you don't list it in section 6, you're okay, but it's a good thing that there's a section 6 where you can actually add in what you've bought and sold in your book, but that has to be in the trust on the deed. If you open up a new bank account, you don't have to call and tell us, just open it up in the name of your trust, or make sure you have the proper beneficiary designation if you don't want to put it in your trust. Either way, it's not going to go through probate, period.
What's nice about the binder, Michelle brought up the binder, section 6, great section to keep current with all your assets, and the beneficiary structure, or if they're trust assets. Great tool for the kids to go to in the future. Go to section 6. These are the assets I need to deal with. I don't have to go through the mountain of paperwork on dad's desk and fish out what he may have owned. If that section 6 is maintained nicely, it's a really great tool for the kids. Also, it's all Schedule A. It's a schedule of intent. I declare that I wanted this to be a trust asset. Most important thing is the titling, but section 6 is a good declaration of intent. Also, section 5, it's our funding section. Tell us about section 5, Michelle.
Section 5 is our funding section.
Very educational.
Funding instructions and asset transfer letters. So if you want to, actually, Rich had a call the other day that somebody wanted to know how he transferred his cows into a trust.
Rich, I buy and sell cows all day long. How do I make them trust assets? And we figured it out. We got it handled. And it was a tool from a note.
Into your trust. That's from Caroline. Bada bing.
But we have a general assignment form. And what we did was we had the guy, he bought cows, he gets a bill of sale, attaches it to this notarized assignment form. I assigned all these cows to my trust. And you sell cows, you get rid of them, lose those bills of sale. So, you're a notarized document telling the world, I intend for all these animals to be trust assets. We had a couple of questions injected here. Let's see. Savings or investment accounts that have a designated beneficiary, do these types of assets need to be added to the trust? We just talked about that. The answer is no. But what if those direct beneficiaries pass away? That asset hits a brick wall. What if the kids are minors or special needs? That gets complex. What if the specific structure is maybe not going to be to your satisfaction? Is it Jimmy and Bobby 50-50? And if either of them pre-deceased goes to the survivor or cascades to their children? Make sure when you do that, you set up the contingency structure like you like. But remember, you can make the trust the ultimate beneficiary. It can find its way to the trust if everybody pre-deceases. But when you do set up those direct beneficiary designations, make sure it's clear on the primary and the contingent.
Right. We're getting lots of questions and I'm trying to read them with my bad eyes. And
quick one, I'll just finish up this one. What if a savings or investment account has a designated beneficiary? Does that override the instructions in a living trust? The answer is yes. The primary distribution is what's down there at the financial institution, and they're going to look at it and what am I supposed to do with this? Oh, give it to Jimmy and Bobby 50-50. If the trust has a conflicting instruction, it's going to be overridden.
Yeah.
Okay.
Did we talk about contingent plan to check on when they put people on as beneficiaries? What's the contingent if those beneficiaries die?
Is it the survivor among those primary names, or does it cascade to the children?
So I would recommend, because every bank is different, like if you have an account that you have like, let's say you have an IRA, it's in your name, and then you have your husband as the backup, and you both pass, then it goes to the kids. What if one of the kids, this happens, guys, seriously, I see it all the time. One of the kids passes. Where is that kid's share gonna go? You better check with your bank, because it doesn't, it's gonna, whatever's on that beneficiary form, some banks say, well, if that kid passes, it goes to the other kid. Well, that kid's share, the parents really wanted that to go to that kid's children. But on the specific form, it says it goes to the other brother. So you need to check with your institutions on what happens if my child dies. Where does his share go on that beneficiary form? Okay.
See, we don't rest here at AmeriEstate until we're very comfortable that your primary structure and your contingent structure is just how you want it in the future. But we're not there to massage that idea if you're down at the bank naming direct beneficiaries to your instruments, for example.
Yeah. Let's see, what's our next subject? We do have some questions, but.
Well, I wanted to say, just overall, call us. We love these calls. We want them. We get, how do I fund my airplane, Rich? How do I fund my boat? My antique artwork, my royalties, my mineral rights, all these are a little bit custom discussion. Principles remain the same. We'd like to direct you on that, but we want to be here to make sure that each and every one of your assets avoids probate. But
Let's talk about US saving bonds and stocks.
Stocks and bonds, usually in a brokerage account, name a beneficiary, create a trust asset out of the brokerage account, or maybe they're freestanding shares or freestanding bonds. It's a complex procedure with the bonds, but what you do is you box up the bonds, you fill out some paperwork, say, I want to title these to my trust. I want to add a POD as my trust. You take the original bonds, send them to the Federal Reserve in Kansas City. They reissue the bonds. We have forms and procedures for all that. Give us a call. Freestanding stock shares, you're probably going to need a medallion guarantee, which is a little bit complex. It's a little bit above a notary, but freestanding stocks, give us a call. We want to work with you today to make sure everything's in place. It needs to be in place to get those stocks transferred. It's a little bit more complex, but it's a little bit of a custom discussion. But don't ignore those. Grandpa gave me this shoebox full of freestanding shares, and I just left it on the shelf. I guess it's earning money like crazy. But don't forget, those are subject to probate. So let us maintenance those today. Give us a call.
We have a question about how do you recommend handling a safety deposit box in a bank? Ooh, that's a good one.
Great one.
Name it in your trust. And if you don't name it in your trust, put a beneficiary on it. Somebody needs to get access to that, right?
I will be honest, various states has various rules about that, but if you name it in your trust, it at least allows the trustee to have a look at the contents of the box and determine what to do with it at that point. But check with your bank, they have various procedures, but you want it to be considered a trust asset, so you have a named nominated trustee in the future to be able to deal with the contents of that box.
Here's another one. If my husband and I own real estate with a deed titled husband and wife as joint tenants, then upon the death of the first spouse, would that surviving spouse receive the property without going through probate? Yes.
Joint tenancy, by operation of law, it will flow to the surviving joint tenant.
But you better put that in your trust now, because you're the last man standing, right? Or last woman standing. Now it's time to put that into the trust.
Yes.
But there's a really good, there's another subject that we're not going to get into, but I'm just going to touch on it real quick. Joint tenancy, when the first spouse passes, only gets a half a step up in basis. You bought it at 100,000, it's now at 500,000. You only get a half a step up. So what if you want to sell that property? You're not going to get a full step up. You're going to sell that, the property is going to keep going up. You might have a capital gain going on there. So if you have your assets in a trust upon the passing of the first spouse, it gets stepped up to the current value. Good time to sell the property then, no capital gains. But if it's not in a trust and a joint tenancy, you only get a half a step up. Talk to your CPA, put that property in your trust when you're married. for that specific reason, and it won't go through probate if you're both on title when one spouse dies, but there's more of a tax thing going on capital gains.
Since the question came up, that's joint tenancy, husband and wife joint tenants. There's also, look at the deed. Are you tenants in common with somebody? That's the line in the sand. That's where my half is going some direction and his half is going some direction. Line in the sand. You can, if you have joint tenancy and you want your 50% in your trust, you are breaking the joint tenancy and creating a tenants in common. 50% to this individual, 50% is in my trust. And if that guy passes away, subject to probate because he's not in a trust, my half is going to go distributed through my trust without probate, but recognize that now whoever inherits that is going to own that with this other party. So that's tenants in common, line in the sand versus joint tenancy. By operation of law, the ownership flows to the surviving joint tenant. But when the last joint tenant passes away, here comes probate. So that last joint tenant should be calling us for a trust the next day.
A couple other questions. When you make changes, do you need to have it notarized or just a witness? It depends. If you're doing an amendment to a trust, we recommend notarizing it. That is the foolproof way of making sure that those amendments will stand. Wills are only a witness document. If you're going to update your executor or even your healthcare directive, those are just a witness document. But amendments to the trust are a notarized document, so we do recommend that.
Did we talk about crypto yet?
No, but we did have somebody ask about Robinhood accounts, stock accounts as well.
Not familiar. Give us a call.
Yeah, Robinhood is for the millennials, I think. No, I don't know,
Not familiar.
but no, yeah.
Good.
Yeah,
Good.
it's a lot of the younger folks are doing Robinhood. Are there fee for changes? It depends. If you're a member in the legal plan, you get a great discount. The trust, section 2, it's free. If you need to update your powers of attorney for health and asset, we offer a really nice discount, and it's not expensive to update those documents. And then also, if you need deeds done, there is a fee for the deeds, but we'll give you a discount as if you've been a member for years.
And the neat part is you're a member of our legal plan. As a member, you'll be given a custom quote before you're obligated to any fee structure, custom quote, and you're not on the clock. It's not like you don't know what this is going to cost. You know what it will cost, and we'll engineer the nice discount as the legal plan member, or many of these features are free. So maintain that membership. We encourage that.
There's other Stanley. We talked about how do you handle U.S. savings bonds with co-owners and one dies. Sorry, I didn't get the second line there.
Well, how is the bond held? As a joint tenant? Does the ownership flow to the co-owner or something different? I'm suggesting when you say co-owner, it's going to flow to the co-owner.
Yeah, so that shouldn't go through probate, but there could be a step up capital gains because that's not titled into the trust. So talk to your CPA on that, but it won't go through probate as long as you both were co-owners as joint tenants on that. Or community property. If it's community property, you get a full step up in basis, guys. By the way, you could do husband and wife community property with right of survivorship. That will give you a full step up in basis on the first spouse passing. So that's a much better way to take title if you don't have a trust on any asset, period.
By the way, all these questions, anything we didn't get to, we'll be sending out an email with responses to each and every question. That's coordinated in here, and give us 5 business days to get that out the door.
Here we go. How do you recommend handling cars and RVs?
We didn't do that yet? Oh,
no,
gracious.
We didn't. That was on our list, so thank you.
Okay, the RV as probably quite a valuable asset, we would recommend retitling to the trust. Go down to the DMV and recut the title, not the registration. Don't worry about the registration. Recut the title into the name of the trust. Antiques, expensive vehicles, the $80,000 Mercedes, retitle. But the average family vehicle, Especially in California, all DMVs are a little bit different in the various states. California is very accommodating when a person passes away to get a vehicle transferred. But having said that, the average family vehicle, don't turn yourself on your ear to get that retitled to the trust. But when you trade in that car and you're down at the dealership and you're buying a new vehicle, hey dealer, close the name of this title right in the name of my trust. Good, better, best, you wanted a trust asset. Like RVs, absolutely, for sure. Trailers, yes. Any kind of expensive vehicle, but the average family vehicle, likely you're going to trade that in, and so don't turn yourself on your ear again, but recognize that should be a trust asset.
Mhm. Here's one, do I need to change my will if I move to a different state? If you have a trust with AmeriEstate Legal Plan, that has a will within it as well. So if you
coined a pour over will,
according to POUR, it pours into the trust. The will catches assets that don't get titled into a trust and pours it over into the trust for distribution of the beneficiary. So let's say you refinanced a house and you pass away and you forget to put that house in you took it out of trust and you pass. The will is going to catch that, called the pour over will, and distribute it according to the beneficiaries, but it's going to have to go through a probate process first, and wherever the property is located, it'll be a probate in that state. Now, if you move from a state to another state, the trust will move with you. We do recommend that if you're going to stay in that state, that you update your powers of attorney for health and finance and your will for that state specific language. The trust will travel with you, but we can give you an attorney referral to do those updates for you in the states that we're not in. But yeah, keep in mind that you might want to do at least the powers of attorney for that state specific info.
But the good news is the trust we create to be portable to the new state.
Yeah.
And frankly, a lot of people move, and if they're not making changes to their wills or their powers of attorney, they have maintained, the California one we gave them and moved to Iowa. And very often they work perfectly well. But again, if you're going to be there a while, we would recommend getting Iowa state specific powers of attorney. If you're not monkeying with your will, probably not necessary to maintenance the will. But if you're making changes to the will, probably a good opportunity to update the will to a pour over will for Iowa, pointing it to that California trust we gave you. Mm-hmm. When in doubt, call our member services department. Those folks who field these calls all day long over there, they want your call. Call AmeriEstate, ask for member services, and boy, they get that call probably every day. Hey, I've moved to a new state. What do I need to do with this binder?
Okay, here's one. My wife who's deceased had quite a coin collection. What do I have to do to get them into my trust?
Okay, how is that coin collection identified as an asset? Was there ever any bill of sale associated with it? Was there ever an appraisal done? But we would take any documentation that you have identifying that collection, or maybe you need to start from scratch, take pictures of it and create an assignment of that asset to the trust. So yeah, you want a notarized document that says, I hereby declare and tell the world that I want these coins to be a trust asset.
And there's assignments in section 5 of your book in the back. You can actually write in coin collection, assigning to the trust, get that signed and notarized and pop it in your book. And you don't need to let us know every time you add something to the trust. We don't need to know that unless you feel like you want us to keep something on file in our records for you, but just remember your rules. As life goes on, things change, you buy and sell. If you're going to sell an asset, it's out of your trust. Don't worry about it. Just cross it out in section 6 of your book. Let's say you are loaning somebody money and you have a promissory note. Assign that promissory note to your trust. There's an assignment in the book.
Or remember what I said, you cut that promissory note tomorrow, due and payable to your trust, then you don't have to do the assignment. It's due and payable to your trust. And that's what you want. You want that trust when you pass away to be there to accept continued payments from that promissory note.
Yeah, you want people to know what if you've loaned friends money and you don't have any kind of proof of it, well, list it in your book that so-and-so, here's the note I did, and kids. Because that's part of your kid's inheritance. And if nobody knows about it, that could just go away.
Listed in tab section 6 as a note receivable.
And if I did not get to your question, crypto, can we review crypto?
It's such a new animal that there's laws being created now about crypto, but we've done the best we can. We give a dedicated section in your binder that you declare all your digital assets to be trust assets. That's a great start. Beyond that, we're recommended that you have somebody that can access your digital wallet to get access and be able to distribute those assets upon your passing. But direct titling, new laws, it's evolving. Give us a call, talk to your financial advisor, but it's a new arena. It's a new arena, but we're doing the best we can for you to tell the world that you want all your crypto assets to be trust assets, all in the spirit of probate avoidance.
Okay, so should personal property like guns be placed into the trust?
That's so interesting. I get this call all the time. Rich, I'm told I should get a gun trust. So we refer attorneys out for gun trusts, but if there's something to identify the ownership of that gun, bill of sale, title, assign it to the trust, and we'll help you do that. Give us a call.
Mm-hmm. And there are a few more questions, but we're going to send you an email directly to handle your specific questions. So don't worry, if I haven't answered your question here, we will get to you. Don't worry about it.
We wanted to hold this to about 45 minutes, and that's where we're at.
Yeah. So I think we're good. So thank you for joining us today. Have a great week. Enjoy your St. Patrick's Day.
Don't ever forget to call us with any question at all. Don't ponder it. Just pick up the phone, 800 number. My philosophy, when in doubt, pick up the phone, call us, let us deal with the asset. Let us deal with the situation. Let us guide you. That's what we want. We want to be here to be able to support those documents that we provided.
Yeah, and that's why we're a legal plan membership, to support you as the consumer for little questions and things that you have. Because if you're going to call an attorney direct, guess what? The clock is ticking. That's why AmeriEstate exists. Your clock doesn't tick. Our clock doesn't tick. Just call us and we'll help you. And that's why we're here, to be of service to you from the beginning to the end and beyond.
Thank you so much for your
joining us.
participation today on this very critical topic, and we're so excited. We hope to hear from you.
Bye.
Thank you. Bye.